Right, it's now 2:35. I think that's a decent amount of time. So welcome everyone, and this is the final year, the final task force meeting for Queens of the Year. And so, celebration, we made it. It was definitely a bumpy road from the beginning to the end, but at least we are here, and that is an achievement for all of us. But we do have some tough times ahead of us, especially with the new year and the eviction moratorium ending and 40,000 eviction cases that have been filed against tenants in New York City since June. So we're going to go through some tumultuous times, celebrate what we've accomplished, but get some rest, get some energy for the battle that lies ahead. And so, as you know, today we're going to be talking about the rights of undocumented tenants, but because we are a housing court organization, we're going to talk about what for specifically undocumented tenants regards to housing and housing court and all those other levels of institutions, though I'm sure there's other types of rights and other fields of study. But we're no experts on, at least I'm no expert on that. So I'm going to share my screen now for a presentation. And so my name is Kayla Papachet. I will be the facilitator today, but this is presented by Housing Court Answers and Mobilization for Justice. So Housing Court Answers, if you don't know us, we are a nonprofit that is citywide. We help facilitate and give informations to unrepresented litigants throughout New York City within Housing Court. So we have a hotline that tenants can call and ask questions regarding, different things that they might need information for, or whether you need rent arrears assistance. If you have a question and it's regarding housing, you can call us, and we can also make referrals to other different organizations and agencies that might better suit you. But that's just a little bit about us, and you'll learn more later about what Mobilization for Justice is. And just so we can, clear the air, some ground rules. First, this is our agenda. First and foremost, we're going to talk about why this issue matters, though if you're here, I'm sure you have an idea. And then MFJ is going to give their presentation. And then after their presentation, we're going to do a Q&A. So if you have a question, you don't have to hold on to it. Feel free to write it in the chat box. And myself, or one of my coworkers will take these questions and put it onto a separate Google Sheet. And at the end, we're going to go through each of the questions that you guys asked in the chat box. And so if you want to talk or if you have questions, feel free to use the chat box. Just keep your mics muted so we could give our full and undivided attention to our presenters today. And so again, one mic, when they're presenting, please keep your microphones muted so that we don't hear any background noise, and just, respect each other. This is a safe space, but that is to say that no bigotry will be tolerated. So, just don't say anything, it's bad. And so we're going to go on. Everyone knows that, New York City is an international city. This city is largely made up by immigrants, whether historically or culturally, or even just the people that are here today and continue to come to the United States and find a home in New York City. But the problem now that we have to face, and this is no news since COVID, undocumented and immigrant people and also undocumented people have had a lot of obstacles that have been created against them by the state, the government, and all those institutions that protect them. And that is also landlords. I can tell you from my own experience, I've had landlords call and ask us and, mention, told their tenant that I'm going to call ICE on you if you don't pay rent. These are some of the things that undocumented tenants and, immigrant tenants also have to go through. And since COVID alone, here's a report written by, it was written by the city, NYC, but it was a separate report by the Center of Federal Refuge. And it said that an estimated of 192,000 undocumented workers in New York City have lost their jobs. Now that was from June. It could have gone down. It could go up again, as we do see that and there will be more lockdown measures being replaced and put in again since our COVID rates are going up. But over half of New York City's immigrants find themselves unemployed. And that alone is a huge, huge obstacle for them because their only income, because of the way that our political structure is set up, their own income is, their own job. Many of these people cannot find themselves in positions of getting assistance like people that are citizens would, or even if there's some avenues for them to get assistance, it could later affect them in immigration. So They are in a precarious position. Even so, one, tenants, which is already difficult, but then also being immigrants and being undocumented and having to deal with this pandemic under a government that's constantly attacking them. And so I want to watch a couple of videos. So I know, we might have our opinions about New York Post. This is just a video from the Post, but we're going to watch what Cuomo said talking about renters assistance. So just give me a second for it to load. And of course, here we don't use the term illegal immigrant. Nobody is illegal, undocumented.
We don't get the federal government to actually pass a piece of responsible legislation. And I've said to the extent they care for my 2 cents, our senators, don't pass a piece of legislation if it's not responsible. Well, then they'll say we didn't pass legislation. Yeah, say I wouldn't I wouldn't pass an irresponsible piece of legislation. Better than passing an irresponsible piece of legislation, right? If those are the options, life is options. So yeah, we are at a point financially where we have a $10 to $15 billion deficit. Yesterday I was asked about, well, why not just let the raises go through for state workers? When you are broke, it would be irresponsible to do these things. I do hope and believe the federal government should have a more inclusive policy. All right, let's do it. Well, we're looking at it, but we have real financial problems right
now. And so, this is our governor who's just putting aside the very real needs for not only state workers, but also undocumented immigrants that, well, we're too broke to care about them right now. Well, there's going to be some real consequences to that. 1 second, please. Okay. And here's a story about a family in Staten Island and how they've had to survive through the pandemic being undocumented.
Armando Villanueva has a small car repair business, but he hasn't fixed a vehicle in a month. His wife cleans houses, but her work has ended too because of the coronavirus.
I'm worried. I have my kids, I have my family, and do not forget that people like me, they are immigrants living in New York. We also send money to our people in Mexico.
The Villanuevas, who have 3 children, say they've been using their small savings to pay for rent and food. But they say it's going to run out soon. And when it does, they will join so many other newly unemployed New Yorkers needing help to meet their basic needs. So for the first time, the Villanuevas say they will head to food pantries and soup kitchens to feed their family.
People like me, we really going to need it in a couple of weeks.
Advocates who help combat hunger say the family story is now a common one. Many in the city were thrown out of work when businesses shut down because of the virus. The problem is especially acute for New Yorkers like the Villanuevas. As undocumented immigrants, they are ineligible for state unemployment and federal stimulus checks.
What this has done is exacerbated many low-income populations in vulnerable communities already.
Erica Frund works for the West Side Campaign Against Hunger, a citywide emergency food pantry. She says the $170 million emergency food program the mayor announced Wednesday couldn't have come at a better time. Lines at food pantries and soup kitchens have been lengthening for weeks. The mayor's plan contains $25 million to make sure the pantries are stocked. Armando Villanueva says he doesn't know how he'll be feeding his family otherwise. On Staten Island, Amanda Farinacci, New York 1.
So this just highlights the very real and very common story that we're seeing right now for our immigrant population being, neglected, being isolated, and not having the access to resources. As they highlighted here, people that are undocumented don't qualify for the stimulus checks. Well, if you are even married to a citizen and you are undocumented because you filed taxes there, that entire family is no longer now eligible for the stimulus. It's thousands of people all throughout the country and also the city and the state. And for example, also in night FEPs, if there's an undocumented person in the household, they are not included into the housing program, or they'll have to pay their own market rate for the rent. So, because these are federal subsidies. There are some legal services that undocumented people don't qualify for because they're also federally subsidized. So they're put into a precarious situation, one as being tenants and being, working class and unemployed now people, and now they don't have any of the benefits that people that are citizens aren't finding to be enough as well. Imagine it without that. So this is why we're having this conversation today, because we want to highlight some of the struggles, one of the undocumented immigrants and our fellow tenants in the city, but also to talk about, well, what can be done. And we're going to, we're talking about COVID, but we're also going to talk about discrimination. Here at Housing Court Answers, many of us have filled out illegal lockouts for undocumented tenants who were thrown out by their landlords because they couldn't pay rent, because they had no way to even make small payments, or if they were falling behind before, they'll just do illegal lockouts. So get out. Or they'll say that they're going to call ICE and threaten their immigration status. And this is discrimination. So we have two presenters today who are going to go talk more about that. And so the first one is Ezgi Yilmaz. She is a staff attorney with the Bronx Housing Unit. And then we also have Patrick Tyrell, who is a staff attorney in the Mobilization for Justice Manhattan Housing Unit. And so this is just a little bit more information about Housing Court Answers. If you ever want to call us, you need any assistance, have any questions, here's our, I missed a number, but there's 962. And we're open Monday through Friday from 9 to 5, except for on federal holidays. Do follow our social media. So we post these trainings. If you maybe want to go back to some details, or if you want to send it to somebody, we post it on our website and on our YouTube. And on our Twitter page, every week we do a weekly topic that we give information on. And so this week is about immigrants and the different resources and different avenues of information, and also just highlighting the cultural history of New York City that has been brought by our immigrant population. And this is my email. If you have any questions, you want to contact us, feel free just to reach out. And so I'm going to pass it along to you guys at Mobilization for Justice now.
Thank you so much, Kayla. We have a presentation that I'm going to load up right now. Just give me 1 second. There we go. Okay. Is the slide now showing?
Yep, all good.
All right, great. So yeah, thank you again, Kayla and Jessica, for inviting us. My name is Patrick Tyrell. I'm a staff attorney with MFJ, and I'm joined with my colleague Ezgi, who's a staff attorney in the Bronx Project. Just very briefly, MFJ provides civil legal services in lots of different forms all across the city. We have a housing project that serves Bronx, Brooklyn, and Manhattan tenants. We have public benefits projects, workers' rights projects, economic justice, children's educational rights, and disability and aging rights. All of our practices can provide services and representation to clients regardless of immigration status as well. So across all of our practices, we represent or work with organizations that are really the forefront of the rights of undocumented immigrants. So the presentation today is going to focus specifically on housing rights and navigating the housing court system as an undocumented tenant. So let's start with our agenda. And Ezgi and I are going to pass the mic back and forth as we go on different slides. So.
Hello, everyone. Thank you for coming to this discussion. I'm so happy to see so many people here. Today, we're going to, just as my colleague also stated, we're going to go over some basic housing rights for undocumented immigrants. And we're going to go over some of the discrimination and harassment that undocumented tenants might face and how to navigate the housing court, as well as MFJ's organizing work in these communities. And then afterwards, we're going to open up the discussion to Q&A, and I'm happy to hear your questions about. All right, so the current landlord-tenant law in New York makes no distinction on the basis of immigration status. And as so you might know, New York City is a sanctuary city. This means that the courts will not report on your immigration status, and they will not, when you file a case, they will not ask for any social security numbers or any kind of documentation that would reveal immigration status. Also, green light law allows undocumented persons to apply and get obtain driver's license, and that can be used as identification in the courts. Undocumented persons have the same rights as everyone else. They have a right to the court process. They have a right to, to get a rent demand 14 days in advance before a petition is served. They have a right to bring an HB case and a 7A case for repairs from their landlords. And they are also entitled to be free from illegal lockout. However, undocumented tenants may still have reservations about exercising their rights. There might be sometimes self-eviction. They might preemptively leave their apartments even before a court case is being started because they may not want to be involved in a process with the authorities. There might be a fear of retaliation by the landlord. Sometimes there might be threats that the landlord will call the authorities, to immigration authorities, and a threat that the landlord may cut essential services. And that there is also, as Kayla mentioned before, there's a limited government assistance for rental assistance and the risk of public charge. So undocumented persons have to make these choices that are difficult, and they're also sometimes not eligible, generally not eligible for public housing, NYCHA usually. There are exceptions depending on, let's say, if there are other documented persons in the household, they might be, if they're already residents. But generally, they have limited options. Although sometimes undocumented parents may apply for assistance throughout their citizen children. Here, I wanted to include this just as a sample. This is what it looks like nowadays. There's a notice the tenants to answer. Anyone who's brought into housing court will get these nowadays, and they can call to answer, and there should be Spanish-speaking staff in court to help them answer. And that at no point when they answer, they are not supposed to ask for any documentation on immigration status.
All right. So I'm going to just go over the briefest, most concise summary of rights based on types of housing. So as Ezgi just went over, I mean, housing courts are essentially not supposed to distinguish between litigants based on immigration status. Accessing the court system either as a defendant or as a petitioner in a case, if you're bringing like an HP or a 7A or some other affirmative case, a tenant's immigration status is not supposed to be relevant. However, as practitioners and tenants and other advocates know, oftentimes those protections afforded aren't enough. So I'm going to go over just an overview of additional tenant protections that flow not from anything to do with immigration status, but has to do with the type of housing accommodation in the lease agreement. So, up at top is rent regulated tenancies. These are rent stabilized or rent controlled apartments. These are some of the most protected and the most common types of regulated housing in New York City. Tenants, again, regardless of their status, have a right to a lease renewal. The landlord can terminate the lease only with good cause. Good cause is usually in the form of saying the tenant got behind on the rent. It could be saying that the tenant is causing a nuisance or breached a substantial obligation to lease, or the tenant no longer resides primarily in the apartment. Those are just some examples. But the landlord cannot just say, I don't feel like renewing your lease. Of course, it's not for a discriminatory purpose. I just don't feel like doing it. That cannot happen in rent regulated apartments. There are caps on rent increases, and of course, there's succession rights for family members, both traditional and non-traditional family members who are not on the lease that have co-resided with the tenant. One thing we want to be clear about is that good cause to terminate a lease in a rent-regulated apartment is not just the landlord's fears of being investigated by law enforcement due to the tenant's perceived immigration status. We've seen that issue come up before, or at least we've heard of tenants who have their landlords try to have these sort of candid conversations with them, say, look, I just don't want to get in trouble myself for harboring an undocumented immigrant. That's absolutely not grounds for any sort of termination in rent regulated housing, and probably amounts to some sort of unlawful immigration discrimination, which we'll go into shortly. The other category of protected housing in New York is public or subsidized housing. This is more commonly in the form of NYCHA, which is public housing that's federally subsidized housing that's managed by a city agency, and also Section 8, which is a federally subsidized housing that can sometimes be managed by city agencies, other times it's managed by private landlords. But either way, under these programs, tenants are afforded greater rights and protections. Now, as he mentioned, in federally subsidized housing, oftentimes undocumented tenants are not eligible for subsidies or to be even on a lease in public housing. However, there are pretty big exceptions to this rule that are exercised pretty regularly in New York, where someone on the household composition has immigration status that qualifies the entire household, including the ineligible tenants to receive those benefits. And fortunately, due to the upcoming change in our federal executive and presidential administration, a very bad rule that was going to come down that would have basically revoked eligibility for entire households unless every single household member could prove their immigration status or qualifying immigration status, is probably not going to go through. So, as we know, elections have consequences. I'm sure I don't need to preach to the choir here, but we're all very happy about that not being promulgated. One thing that we want to talk about just briefly when we're talking about Section 8 especially, a landlord cannot refuse to accept a Section 8 voucher for basically any reason. There's protections based in New York City based on what's called lawful source of income, and it is unlawful discrimination for a landlord to say, I don't take vouchers. So oftentimes we'll see landlords try to take that position, and it's completely illegal, and we'll talk more about how tenants can fight back against that. A couple of other categories just to go over, there's unregulated tenancies with written leases. That's what we might refer to, are also known as a market rate tenancy. This is one where they're not regulated. There's no Section 8 or any other federal regulations. It's basically just whatever the written lease agreements says, those are the kind of protections the tenant has. Obviously, every single tenant, regardless of their lease, is protected against discrimination and unlawful harassment. But these types of tenancies, there's no right to a lease renewal. There's no right to having, rent caps, that sort of thing. So oftentimes, when we're working with undocumented tenants, we want to make sure to see, are you regulated? Is there any possibility that you could be rent regulated? Because if they're not, then the landlord at the end of that lease term could just opt to not renew the lease. And there's some ways that a tenant can fight back on that legally, but they're very hard to prove, and they can become very complicated. The last category I want to talk about is unregulated tenancies where there's no written leases. This is what we call a monthly tenancy or a month-to-month tenancy. Basically, the tenant is afforded very few rights in terms of having if the landlord wants to terminate that lease, given that tenant 30 days notice is basically what the tenant has before they get brought to housing court, and it can be very difficult to prove defenses to an eviction case, and a landlord ultimately prevailing. And working with undocumented tenants, oftentimes tenants will live in a lot of precarity, and they may live in illegal units, or they may live in basement units that have no written lease. There's really no written contract that shows their tenancy, and they do have basic rights to notice before being brought to court, and of course they have rights against being protected against harassment and unlawful discrimination, but basically it's at the landlord's option as to how long they want to keep that tenant there as well, and they really just have a right to have a notice before the court proceedings brought against them. So moving on, we wanted to, oops, a little too far. Sorry, I'm doing double duty. So let's just talk about basic terminology too when we're talking about discrimination and harassment that's based on immigration status. So unlawful housing discrimination, in a nutshell, I would define that as an unequal treatment by a landlord or lender based on the tenant's protected class, and that protected class can include the tenant's actual or perceived immigration status. So all New Yorkers, regardless of their immigration status, are protected by federal and state anti-discrimination laws. These basically limit the ability of the landlord to do things like refuse to rent to undocumented tenants, threaten an eviction based on immigration status or perceived immigration status, or harass the tenant solely because of their actual or perceived immigration status. And those protections flow both from city and state human rights laws. They also protect the tenant against retaliation. They prohibit the landlord from advertising, saying, we'll only accept applications if you have a social security number, if you can prove your immigration status, that sort of thing. And it also makes it illegal for the landlord to make inquiries about immigration status as part of the lease application process. The law is a lot more expansive. There's a lot more detail to it, but that's just kind of what it states in a nutshell. So, and then, corollary to that is New York City and state anti-tenant harassment laws. So there's some overlap here. Now, the housing discrimination laws make it illegal to retaliate or harass a tenant. The tenant harassment laws kind of get into more detail as to what legally constitutes a civil harassment claim against the landlord. So again, in a nutshell, harassment is defined as any act or omission by the landlord or by one of their agents, like a super or a management company, that causes or is intended to cause a tenant to surrender or waive any of their rights in relation to occupancy of their apartment. So that's what the law states. And then there's kind of this laundry list of examples of harassment that's contemplated within the New York City codes. I'll just go over some of the common ones that we see litigated in housing court, or that we talk to our clients about. Interruption in essential services is the one I probably see most often. That's where a landlord's failing to provide adequate heat or hot water, electricity, cooking gas, heating gas, any sort of essential service that allows the tenant's apartment to be habitable. And there's a bit of a gray area as to how much is this a landlord just being negligent and being lazy versus is this an intentional act of the landlord that's causing the, trying to induce the tenant to give up their apartment and basically self-evict. And it depends on a case-by-case basis, but this is the one that we see so common. Another one is just baseless court proceedings. Landlords that will every year sue the tenant and make up completely phony allegations against them. To just constantly keep them in this revolving door in and out of housing court. That's a very common one. And just to be clear too, under the city harassment laws, requesting an identification that would disclose citizenship status when a person's already provided their current identification. So, let's say you provide your New York City ID or something like that, and the landlord says that's not good enough. I'm going to need to see your social security card, or I'm going to need to see some other form of ID that might disclose your citizenship status. That is also considered unlawful tenant harassment under New York City codes. Again, we just wanted to make sure that there's this understanding between the two, because, depending on what sort of actions the landlord takes, it might guide, the tenant's legal options as to what kind of filing they might put in, what kind of defense they might have, which, we're going to go over a little bit later in this presentation. I'll pass it back to Ezgi for this one.
Just repeating again, in New York City, landlords cannot threaten the tenants based on their citizenship status or immigration status. There is a longer list of categories that a landlord cannot threaten based on, but just to give an example, they cannot say, if you don't pay your rent, I'm going to report you to the authorities. Or they cannot say that, for example, that they're going to share it on social media, your immigration status, or that they're going to take out, let's say, essential services, the stove. So that's one of the things that our tenants are protected in New York City by the administrative code. The landlords also cannot request identifying documentation that would disclose a tenant's immigration status. For example, let's say when you're applying to get an apartment, they cannot ask you to prove your legal status, immigration status, in order to give you a unit. And that's usually not required by law. Anything that's not required by law, as long as the undocumented tenant gives other official identification.
Right. So let's talk about what the tenant's options might be to fight immigration discrimination and unlawful harassment. So these are examples of affirmative cases or complaints a tenant can bring. I should also note that if a tenant's already being sued in an eviction case, let's say, for instance, a tenant is sued. So let's just say, for instance, a tenant, is an unregulated tenant. Maybe they have they don't have no lease at all, so they're considered a monthly tenant, so they have the least forms of protection. Let's say that they call 311 because the landlord's not giving them heat. Then the landlord comes to them and says, stop complaining to the city, I'm gonna get all these fines. If you keep doing this, I'm gonna call ICE. I'm gonna ICE you and we're gonna get you deported. And so the tenant continues to call 311 because they know their rights and they need to have heat and they need to have a right to habitable apartment. So the landlord ends up, instead of calling ICE, they just bring a holdover case against them saying, okay, we're evicting you. The tenant can assert a defense and a counterclaim in that sort of case for retaliatory eviction. So basically saying that the landlord brought the holdover case in bad faith. This is really just trying to retaliate against my good faith complaints to a city agency. And you could also bring counterclaim for immigration discrimination, saying that in addition to this, the landlord told me that they were going to call ICE on me. So I actually also think the landlord was motivated by unlawful discriminatory intent. So that's just an example of how this could play out in a defensive case where a tenant is defending eviction. So these are just some basic ways and avenues that a tenant could bring an affirmative case, so file a case themselves. For an immigration discrimination claim, of course, they can file a New York State Human Rights Commission complaint. That's an administrative complaint. It doesn't go through a court system. It goes through an administrative process where New York City Human Rights Commission attorney will investigate. They will try to get the facts from both sides, and there will be some sort of action taken on behalf of the city. Sometimes those complaints may, my understanding is that they may develop into some sort of affirmative litigation depending on the severity of the complaint and other facts. But the first step is to report that to the city agency if a tenant believes that their landlord is engaging in unlawful discrimination based on their perceived status. The other option, any tenant has is to bring a case in civil supreme or in federal court. These sorts of cases, you would definitely want to have an attorney to bring these. I mean, they're going to be very complicated. It's going to involve, possibly a long time, very lengthy litigation, complex litigation. But the state and federal anti-discrimination laws do give tenants a cause of action that they can bring in those two forms as well. When it comes to landlord harassment, so again, we're talking about a landlord trying to force a tenant out of their apartment, by engaging in some sort of unlawful civil harassment. Rent-regulated tenants have an administrative option that's to file a DHCR harassment complaint. So similar to the Human Rights Commission complaints, that's an administrative option. You don't have to go to court for that. The state agency that oversees all rent-regulated apartments would have a hearing officer oversee that complaint and investigate it and everything. A more common route that we see for tenants is to commence an HP or even a 7A for harassment in housing court. So because a landlord has a duty not to harass tenants that's stated in the Housing Maintenance Code, tenants can bring these kind of actions solely for harassment. They can also bring a mixed complaint if there are repairs and harassment, which again, we often see these because withholding essential services is one of the more common ways that landlords engage in unlawful harassment. So tenants can bring those proceedings in housing court. They do not need to have a lawyer to commence those cases. There are forms that pro se tenants can fill out to commence the cases that have instructions on service and everything like that. I will say that from my experience, if a tenant, wants to push a case to some sort of trial over harassment, it is best to have an attorney. Those trials can become very complicated and again, also very lengthy. If it's a case that's really just more about repairs, a tenant may be able to, get what's called an order to correct pretty quickly from a housing court judge who knows what they're doing, and be able to get essential services restored or get other necessary major repairs done quickly. As we've talked about already, I mean, a landlord, they are prohibited from retaliating, they're prohibiting from harassing their tenants in response to these sort of complaints. We know in reality that doesn't stop them necessarily. So, a pro tip I usually give anyone who I'm talking to who might be worried about landlord retaliation is just to document everything. If they're having, verbal conversations with their landlord, try to record them, try to put everything in writing, just try to create a paper trail to be able to show the timeline of the discrimination and harassment, because that could become very important once their case goes to trial. We wanted to talk also about how these immigration and status issues play out in housing court. As everyone knows right now, we're in an unprecedented time where courts have well, now they've basically shut down all in-person operations. Before they did the latest round of shutdowns, it was very limited in-person operations. So this is a very different time to access the courts on a lot of different levels. But we just wanted to go over some of the basics in terms of tenants' ability to access the courts and what kind of rights and accommodations they should be expecting based on the rights they have. So, in New York City, 8.5 million people speak a language at home other than English. So, one very important part of access in New York is that courts must provide language access to all litigants. So that is the rule. There must be an interpreter for in court. And doesn't mean there always is going to be an interpreter. There's a lot of issues that come up in it, but the right is that for all litigants in civil and criminal proceedings, regardless of whether they have an attorney in a civil case, they have a right to an interpreter for every substantive appearance. The reality is that interpreters may not be available on the day of their appearance. There's often substantial delays due to lack of resources and just like coordination. We have been experiencing new issues due to virtual appearances where getting an interpreter, even if we're able to find one who's available for that particular appearance, it is just extremely slowed down and confusing because you have so many cooks in the kitchen and you have to wait for the interpreter to communicate. It's not all happening at once. You have to wait for the interpreter to communicate to the client, and then the client to communicate back to the interpreter and go through that. So it really does slow things down. The pro tip I would just give any tenants, especially unrepresented tenants, is that if they have some sort of virtual court appearance coming up, to try to notify the court with as much notice ahead of time as to the language access requests. That way, rather than wasting time, the court can reschedule the appearance, get the interpreter ready, and everything can be, coordinated with as much notice as possible. But yeah, it's, again, it can be, the reality of it can be very difficult for tenants, especially if they're accessing the court without an attorney. And then just some immigration status issues that come up during housing court litigation. Probably, one of the number one concerns and fears I see when working with undocumented tenants is ICE in the courts. If I show up to my court appearance, am I getting arrested? Am I going to be detained? The Office of Court Administration policy right now is that they won't let ICE agents into any state court without a warrant. I've heard of anecdotally of stories that is contrary to that. I've heard of court officers, possibly coordinating with ICE or at least cooperating with ICE more than they should have, depending on that. But the good news here is that there is the bill that got passed through both of the state legislators, the Protect Our Courts Act, which would prevent immigration-related civil arrests at New York City courthouses. My understanding is that while that bill has passed both houses of the state Congress, in July, Cuomo hasn't signed it yet, so I don't think it's actually effective at this point. Someone could correct me if I'm wrong about that, but either way, the fear of ICE arrests or detainments in court is real still, and perhaps one slight silver lining to this entire shutdown due to the pandemic of in-person appearances is that I think that fear can be put aside a little bit more now because everyone's accessing the court virtually. But the question is going to be, once we restart in-person operations, whenever that's going to be, our undocumented tenants, will there still be this chilling effect? I think there is some positives towards that, and I think we're working towards a better policy, but it can still be an open issue. The other issue that comes up in housing court cases sometimes is immigration status being revealed during discovery. So discovery is a point in a case where one or both sides have to share documents or possibly pre-trial testimony speaking to the facts of the case. In housing court, there is no assumption that discovery is going to happen on every case, but there are certain cases in which discovery may be necessary or ordered by the court. So these are cases usually where a tenant has a burden to prove their primary residency at an apartment. So we see discovery ordered often in succession, in non-prime cases, or maybe in illegal sublet cases where, again, the tenant's defense is, I live in this apartment, and the landlord's saying, no, you don't, or you haven't lived in this apartment for the requisite amount of time in a succession case. And so it's the tenant's burden to prove their primary residency in the apartment. Now, an undocumented tenant who wants to assert that defense may very, understandably be nervous to go into full-blown discovery where they have to provide their taxes, they have to provide, information from their bank accounts, they have to provide all this information to show their residency. We have seen at times landlords who may be, aware, they think they know what the tenant's immigration status is, abuse the discovery process to try to out their immigration status. The rule generally is that tenant's immigration status, even in these sorts of cases where they have to prove primary residency, is not relevant, except for in some very limited cases where maybe the tenant is living in the United States on visas that restrict primary residency. So, the court rules about whether or not a landlord's entitled to this sort of information are actually pretty favorable for undocumented tenants, but the question, as always, is enforcement. So if you have an undocumented tenant who doesn't have an attorney who's going through discovery, the judge is probably not going to be refereeing that discovery, and they're certainly not going to advocate for the tenant themselves. So, if you have a tenant who wants to fight back on a succession or a non-prime or an illegal sublet case, and it's about to go in discovery and they don't have an attorney, it's really best that they really try hard to try to find an attorney to help navigate those issues and try to protect them as best as possible. An emerging issue is also going to be around tenants asserting what's called the new Tenant Safe Harbor Act defenses. So these are new defenses in non-pay cases, although they've been extended to holdovers at least temporarily, where basically a tenant, if a tenant proves that they suffered financial loss during the COVID-19 pandemic, the landlord is not entitled to actually retake possession of the apartment. They can get a money judgment from the tenant for back rent, but they can't actually evict the tenant from the apartment in those cases. This is a very new law that's passed now, and it hasn't really been litigated that much, but advocates, especially for undocumented tenants, have pointed out that this is going to place a new burden, a much more high burden on undocumented tenants, because they have the burden to prove loss of income or qualification of state and federal benefits. So as we know, they're not going to qualify for unemployment benefits. So it's going to be on a tenant who's undocumented to prove their loss of income. So what happens if they work off the books, or what happens if their status may be otherwise, exposed in court, in order to try to assert this defense. These are new issues that we're grappling with, but tenants should be aware of. The bottom line when it comes to these discovery issues and everything around housing court is that, if you talk to any tenant who receives, let's say, a letter from their landlord saying, okay, send me all these documents proving your succession defense, or send me all these documents about all the money you lost allegedly during COVID, a tenant does not have to provide those documents to their landlord outside of a court order. So, a lot of times tenants feel really pressured to avoid housing court, to avoid that, but if you're looking through this list of documents and you even think, for a second that the tenant's status might be exposed, probably the best course of action for that tenant to take is to try to find an attorney and, not comply with the landlord's request, because again, they have no obligation to do so prior to litigation, prior to a judge ordering them. We've already talked a little bit about the abusive process. That's really just, again, comes up mostly in these discovery issues where you have a bad faith landlord or landlord's attorney that might try to use the eviction case as a vehicle to out the tenant status. The protections that a tenant can avail themselves in court, and again, it's really best if they get an attorney to try to do this, because they do have to move for these sorts of protections. There is what's called an order of protection. This is where a judge, either during discovery or during a trial, will limit the scope of of inquiry or documents to be provided, or the scope of testimony, in order to make sure that a tenant doesn't have to disclose their immigration status, or doesn't have to provide certain documents that might disclose that. Attorneys can make motions to seal records. That's one tool that you can have in housing court proceedings in order to try to avoid any sort of undue immigration consequences. And finally, you can request a judge to do what's called an in-camera or confidential review of documents. So, judges do have the ability to be able to look over relevant documents in a tenant's case without it becoming part of the public record. And again, these are all just the kinds of tools that you have in housing court to protect, undocumented tenants who might be trying to navigate the system. And I couldn't stress it enough. These are very complicated rules. The protections, while they're available, can be hard to access without an attorney. So it's really best if tenants try to reach out to counsel before trying to do those sorts of protections. Back over to Leslie.
Best advice for today. Best advice that we can give to undocumented tenants is to explain what they can expect from their court processes. It depends on the type of case. For non-payment, what are they supposed to present? For, let's say, like a non-primary residence case, they would have to present other types of documents about their residence and the apartment. So I think it's very important to give them the information and allow them to make the best decision for themselves, because at the end of the day, it is the tenant's life and liberty it's their life at stake. So sometimes the risk of, let's say, like applying for certain benefits might be worth it, but it's important to explain it to them.
So we also just wanted to talk in a little bit more depth about MFJ's work with migrant communities and working with undocumented tenants. So of course, as we talked about already, we do provide representation in housing court, both affirmative cases, HPs and 7As, as well as eviction defense. We have, we've also been providing some limited defense for rent strikes as well, which has been an emerging issue this year. So if you're working with any tenants that may be interested in pursuing those issues, we can at least interview them, do an intake, and of course their immigration status wouldn't be any sort of barrier for accessing our services or even representation. We do have immigration and public benefits projects that work a lot in migrant communities. We work a lot with different schools and houses of worship to develop partnerships and programs in order to serve their constituents and their communities. We do we do policy reform on all different levels. That can range from lobbying, some limited lobbying, to legislative drafting, to working on research and other issues that can try to steer towards better, more sensible policy, and that obviously does touch in immigration policy as well. One example is that we have been working with the DRE and SCRE rent freeze programs to make some important changes to disincentivize or to steer clear of discrimination based on immigration status in terms of a tenant's eligibility for those programs. And of course, as I mentioned before, we do community partnerships with community-based organizations, nonprofits, different religious organizations, schools. So if there are anyone that's working for organizations that are interested in community partnerships, especially revolving around housing issues and immigration status, of course, reach out to us. We'd be more than happy to talk. So with that, concludes the presentation, and I think we should go right into questions, because I can see the chat notifications are already filling up.
Yes, thank you so much for this presentation. And yeah, we have about 15 questions just right now. But guys, go ahead and add your questions to the chat box. I'm taking them all in order and just to try to decipher them. So the first question that we have is, how do tenants fight against housing discrimination?
Good, very good question. I think I would refer back generally to our slide about fighting, asserting your rights on discrimination cases. Again, just as a quick overview, housing discrimination claims can be asserted in an eviction case as both defenses and counterclaims, depending on the nature of the case and the kind of discrimination a tenant's facing, but also affirmatively speaking, I think the New York City Human Rights Commission is one of the best places a tenant can go to, not only for resources on learning about their rights and what counts as housing discrimination, but also filing complaints and asserting their rights as well. They have a pretty streamlined, easy to access complaint process. I believe the complaints can be filed completely online at this point, as well as over the phone. The easiest way to probably access the Human Rights Commission is through 311. The tenant can just say that I'm facing housing discrimination, or I'd like to speak to someone with the New York City Housing Human Rights Commission. Again, there are other legal options a tenant may have to assert those claims vis-a-vis filing in state or federal courts. But again, that's something that you really do want to find an attorney to bring those kind of claims. The easiest process, I think, is through a New York City Human Rights Commission complaint.
And so this one, I think this was back when Eski was talking about NYCHA and how certain undocumented individuals that live there are ineligible for the subsidy. So the question is, did you say that if an undocumented individual lives in a family unit, that the whole unit is ineligible for benefits?
No, that means only the undocumented person would be ineligible for the benefits. The other individuals who are citizens would be eligible. For example, usually when we have a case with two undocumented parents, we would help the citizen children open a cash assistance case, and then they could benefit through that.
Many applications for apartments ask for the applicant's social security number. Should an applicant give the social security number to the landlord, or should this be reported?
Very good question. So again, the landlord may be asking for a social security number for some non-discriminatory purposes, including like running a credit check or something like that. Here's my understanding, and just the caveat is that I am not a fair housing expert. I am just a mere eviction defense lawyer. But my understanding is that if the application is denied solely based on the fact that a social security number wasn't provided, that could constitute unlawful discrimination. And certainly, a landlord can't make it some sort of quid pro quo sort of setup where they would say, hey, if you give me your social, probably a better example would be, if you don't give me your social, I'm going to have to charge you a higher rent, or I'm going to have to charge you, a higher security deposit or something like that. That definitely would constitute unlawful discrimination, based on city and state and federal laws. But it can be an extremely difficult process to document and also assert the complaint. Again, I would point to the New York City Human Rights Commission again, because they do have tons of good information on the nuances of documenting the claim themselves and like the kind of questions you can ask and that sort of thing. And they're always very like readily available to help answer specific questions around that, because it can be a very daunting process, especially if you're trying to find housing during a pandemic. I mean, that, like, of course, I mean, sure. I mean, abstractly, yes, you make a huge federal case over these things, but like practically speaking, a lot of people just need an apartment, and but I think that the Human Rights Commission really does have good material on that, and they can probably better answer your questions on a more case-by-case basis.
This next question, I think, and if you might want to go into this because it's a lot of tenants or a lot of people who aren't familiar with the housing court confuse what is a petition or a 30-day notice or an eviction notice. So this question says, can a landlord give an eviction notice to a tenant if it is an unregulated tenant? So if they're undocumented, they have no lease, they're living in a basement. I guess if you just want to go over like what the landlord can do to get the person out, what is an eviction notice? What is a petition? What is the termination notice?
I can go over this. So first, the landlord in a non-payment, when they're seeking rent, they are supposed to serve a rent demand, which should set out for each month what the tenant owes, and give the tenant some sort of notice on so that they can figure out how to pay. 14 days later, they can serve the petition, at which point the tenant has some time to answer. During the pandemic, that time may be more flexible, but sooner or later the tenant goes and answers. Once the tenant answers, there will be an appearance day, so then it will go on. At the appearance day, the tenant can ask for an adjournment to get a lawyer, or they can just assert their defenses. So that's usually how the process goes. I think, but they can still be served with the notice.
And I'll just add, so that's totally true. I mean, there's generally two types of notices a tenant might get, before being brought to housing court specifically. As Ezgi was mentioning, talking about the rent demand and then the 14-day notices before a non-payment case. When it comes to someone who, I think the question was about like someone who was living in an unregulated apartment, right? So, they, if they have a written lease, then, the landlord can't just kick them out for no reason before the end of the lease term. If they fell behind on the rent or they breached a rule in the lease or something like that, they may be able to start a case against them before the end of the lease term. But otherwise, as long as they're paying rent, as long as they're not breaching the lease, they have to, keep that tenant till the end of that written lease. When it comes to a tenant who doesn't have a written lease, then they're considered a month-to-month tenant. Their tenancy renews every month, basically, by law. And as we were talking about earlier, those are generally tenants that have the least kind of protections, but they still do have protections. So a tenant in that situation, first of all, they cannot be, they can't be evicted without some sort of due process. They have to be brought to court. They also have to have notice before being brought to court as well. So the landlord does have to serve a notice of termination, and depending on the length of the tenancy, it may be a longer notice of termination as well. So certain tenants have 30 days depending on their length of tenancy. Other tenants, if you've been, I believe it's more than 3 years, you'll have a 90-day notice before the landlord can even bring a court case against you. And then once you're in court, you may have other defenses to that notice, but like I said before, generally speaking, when it comes to an unregulated tenant who has no written lease, generally speaking, it's going to be up to the landlord whether or not they want to keep that tenant long term or not. Now, when it comes to recognizing the different documents, we do get questions around that a lot. The notices, themselves mean that the court case hasn't started. So if it says notice, or if it says 14-day rent demand, if it says notice of termination, if it says notice to quit, something like that, then the landlord's basically saying, if you don't get out, if you don't pay all the rent by a certain time, then I'm going to bring a court case against you. Not that you're going to get evicted on that date. It means that we're going to bring the case against you. And then after that, the next documents that a tenant would receive would be a notice of petition and petition. That's the one with an index number. Usually it's the one that lays out the elements of the case and everything. That's the one that means the court case has started. But even then, the tenant has the right to appear in court to answer and to assert their defenses. And you have a right to go through the court process. I mean, you have a right to demand a trial over this as well. And to, and again, during these times, that can be a very lengthy process. So by no means a tenant receiving a notice of petition and petition that a housing court case has started, does that mean that they have to get out or that they're at any sort of imminent risk of eviction. But for sure, that tenant should be trying to access legal services. So they should be calling us, or they should be calling Housing Court Answers in order to get connected with an attorney to at least look over the documents and see what kind of defenses they may have.
So if a tenant gets sued, how does the tenant background check, which is also commonly misunderstood as like the tenant blacklist, but it's really just a background check, how does this apply to undocumented tenants? So if they don't have their social security number involved, but let's say they've been to court and they apply for a new apartment, how does that work, if at all, against them?
Good question. So, under the HSTPA, the use of the tenant screening bureaus and the quote unquote like tenant blacklist has been, pretty much effectively banned. I actually don't know I'll be honest, I don't know offhand the nuances around, if a tenant's undocumented, if, any sort of credit, adverse credit impact from a housing court case, if that would carry through with them. I just don't know the answer to that, to be honest. But I'm happy to follow up with you after talking to some of consumer protection attorneys or someone that would know better than I would. But that's a great question. And I will say that generally speaking, having that a housing court case generally won't impact your credit until there's a judgment. So the judgment is the final order issued by a judge saying that you lost the case, that the tenant lost the case, and those judgments can either lead to an eviction or it could lead to a debt, a monetary debt, and that's usually when the adverse credit impacts occur from a housing court case. At least under the new HSTPA rules, just the starting of the case should not lead to adverse credit impacts, and certainly the Tenant Screening Bureau's power has been diminished quite a bit, but those are just the general rules. I'm not sure if there are exceptions or differences if a tenant is undocumented or may not have a social security number, but we'll look into that and get back to you.
And so then piggybacking off of that, since most undocumented people don't have the options to get credit, if a landlord requests a credit check, would that also constitute as housing discrimination?
My understanding is that the requesting of a credit check does not constitute housing discrimination. Where it constitutes possibly actionable discrimination is if the landlord is treating that tenant different, like unequally based on their refusal to provide certain information that might out their immigration status. My understanding is that credit checks are pretty routine, and I think just the asking for that information alone wouldn't rise to the level of discrimination. But like I said, if it then all of a sudden that applicant's declined, or again, they're offered different terms, or they're otherwise have some sort of negative impact on the application process, that could arise to that level. And again, I'll point to the New York City Human Rights Commission for questions on a more case-by-case basis, because we're coming here today knowing some of the more general rules about housing and immigration discrimination. But the Human Rights Commission really does have a wealth of information that can give you more of a nuanced answer based on your specific situation.
Would you know if one spouse, so let's say there's two spouses, of course, and one person is undocumented, one person is a citizen, and one applies for a one-shot deal or any public benefits, do you know if that would affect the undocumented spouse's immigration proceedings regarding the public charge?
I don't have an answer. Do you, Ezgi?
I do not. I do not have an answer for that either. I think that would be more of an immigration issue.
What I will say is that if that person or anyone else is interested in getting an immigration screening on these sorts of particular issues, they should reach out to us, and I'll drop our information in the chat just before we go. We do have an immigration project, and they do screenings on issues like that. We also have a government benefits project that might be able to screen that issue as well. I don't know the answer to that offhand. I can just say that, you know, in terms of eligibility, the spouse with status should be eligible for a one-child, at least they shouldn't be declined based on just their status because they're married to someone who may not have status. But yeah, I'm not sure how it would impact immigration case. I think there'd be a lot more follow-up questions that an immigration attorney would want to know before answering that question.
And undocumented people go into New York City shelters.
Yes, there's no restriction based on that. I mean, we have a universal shelter mandate. Whether or not you want to go into a shelter is a whole other question, and whether or not you want to explore other options in terms of alternate housing is always a question before that. But yeah, no, there's no reason that a shelter should deny you based on your immigration status in New York State.
Are there any protections for tenants that have contracted COVID, and can a landlord evict them?
I wish the answer to that question was different. They can assert the defenses for, you know, Safe Harbor Act and any of the other moratorium defenses, but that doesn't preclude a landlord from starting an eviction proceeding.
Yeah.
I know landlords that have started eviction proceedings against 85-year-old women whose husband is in the hospital and she's been living in this apartment for 20 years, and you know, they can still do it, and it's not fair.
And I'll just add to that too. We went over it a little bit in the presentation, but you know, to be clear, in a housing court case, there is a COVID-related defense to an eviction, but you have to prove hardship. You have to prove either that you're eligible for state or federal benefits, unemployment benefits since March, or that you lost income due to COVID. And you know, even though that special defense is available, there's going to be additional hurdles for undocumented tenants to access that specific defense. And again, that doesn't keep you out of housing court. That just means you can assert the defense in your housing court proceeding. So, you know, the answer is, you know, sadly, no. There's not a whole lot, and there's definitely no blanket restrictions against evicting someone who has COVID or maybe suffering from a financial loss due to COVID.
Is it accurate that tenants who want to be covered by the Tenant Safe Harbor Act or the executive order modifying the act have to raise them as defenses in their eviction case? That is the judge not going to decide whether or not the order applies? They have to actually raise them as a defense in the conference. And can they list that as a defense in the petition? I think you kind of answered this. But.
Yeah, the short answer is that they're defenses expressly in the Tenant Safe Harbor Act. It's a defense in a non-payment case. It doesn't mean that the case can't be commenced. You know, the one thing I'll mention is that there is the CDC moratorium that'll be effective till the end of this month. So it's really, you know, a couple more weeks at this point. But that one gives you the option of sending in a declaration to the landlord to try to basically delay them from filing a case. But to be honest, I think the Tenant Safe Harbor defense gets you better relief in the end. And you can assert both of them, and you can like try to get the eviction defense delayed, or I'm sorry, the eviction case delayed, and then assert your Tenant Safe Harbor defense. I mean, there's ways that they interplay, and you might be able to basically like kick the can down the road using the CDC defense. But yeah, the Tenant Safe Harbor one is very expressly a defense in the eviction case.
Can a landlord or a tenant record the other party?
Yes, in New York, a person can record conversations as long as the person is part of that conversation. Let's say a tenant and the landlord is having a conversation, there's harassment going on, the tenant can record that.
Sorry, I was just adding more questions. What recourses for legal assistance do undocumented tenants have in housing court? So does the right to counsel, which was the law passed in 2017, guaranteeing low-income New Yorkers with the right to a free attorney, does the right to counsel law cover them as well if they are undocumented?
Yeah, there's nothing in the universal access to counsel laws I mean, that restrict eligibility based on immigration status. Those laws only look into I mean, at this point, it's zip code and then your income eligibility. Although that there are proposed laws to expand both of those. There are restrictions. There are restrictions based on funding for different legal services organizations as to whether or not they can represent someone who's undocumented. You know, if the legal services organization takes certain federal fundings, there's strings attached basically, and one of them may be inability to actually appear for an undocumented person in a civil case. Although my understanding is that shouldn't, the buck shouldn't stop there. I mean, you should just be referred to a different agency if that's the case. And if anyone has any problems with that, if they're just getting told no because they don't have a social security number, they should reach out to us, because we don't take that funding, and we can at the very least screen them and try to get them a referral to another agency that could work with them, or at least that wouldn't be barred just because of their status. Yeah.
So this question, what kind of financial assistance is available to undocumented tenants for rent arrears? I just want to say that we at Housing Court Answers, we do individual rent arrears screenings for each tenant that calls and asks us for that. So if a tenant is undocumented or any kind of status, we take your individual conditions and we see what places we can refer you to. But I'm sure you guys, if you guys have an answer you want to add to that as well.
Go ahead. Do you know, Asgi?
No, I think
Okay.
you said it.
So I'm not offhand. I'm not aware of any special funds for undocumented tenants and rent arrears. Although I've been, I've been aware of different mutual aid organizations and much more, how I say, like informal rent arrears funds that have sprung up especially after the pandemic. I think that there are private charities that would be, you'd probably have much more success at trying to access as an undocumented tenant. And just a reminder that if anyone in the household does have status, they should, the whole household would be eligible for, HRA and other federal and state rent arrears assistance. And of course, unfortunately, the paltry COVID-19 emergency rent fund that was established back in June has a bar for a barrier for eligibility for undocumented based on status. So as the video we watched in terms of Cuomo, not wanting to sign anything that would help any undocumented tenants, regardless of being paid millions and millions of dollars in taxes and getting all kinds of labor from them, that's still the case. But I think, I'll just reiterate what Kayla said. HCA is a great resource for rent arrears screenings, and MFJ, we of course can speak with you as well if you're having trouble accessing funds or accessing that information.
What's the difference between a counterclaim and using harassment or discrimination as a defense?
I can take this one unless you want to, Ezgi. Okay. That's a good question. So a defense, a defense to a case is basically saying that either the landlord won't be able to prove their case and they lose, or even if they prove their case, I have some additional facts that would show that they should not get to evict me. And a counterclaim is basically bringing, kind of like bringing a countersuit against the landlord through the eviction case. And so as long as the counterclaim is, as long as the facts of the eviction case are kind of like mixed up enough with the facts of the counterclaim, the court should hear both the landlord's claim and the tenant's counterclaim. When it comes to harassment, it can get, there's no like easy answer to that question, but I'll just say, generally speaking, tenant harassment is, the landlord harassing a tenant is usually not a defense to an eviction case, although depending on the kind of eviction case, I guess it could be. I mean, if the landlord really like filed just an insane petition that said like, I don't know, just was like wholly on its face, like discriminatory or wholly on its face harassing, then you could assert it as a defense. But most of the time harassment's going to be a counterclaim saying that, like, let's say, so a very common example would be let's say tenant has bad repairs, bad conditions, and they withhold rent due to compel the landlord to make the repairs. Landlord sues them for non-payment, okay? The tenant could bring a counterclaim for harassment in that case, saying that the landlord intentionally, withheld repairs in order to induce the tenant to give up their apartment. So that's just one way that the harassment, claims can come up in court. I will say that, there's a special defense in New York for retaliatory eviction. So that's when a landlord files a holdover case within a year of the tenant making good faith complaints to a government agency about the landlord. So, let's say the tenant calls 311, gets violations placed, and then the landlord slaps them with a notice of termination saying they're going to start a holdover. The retaliatory eviction defense would apply there. It would be a defense that the tenant would have to prove and basically say that, landlord brought this case in bad faith because they're just trying to, basically come after me for complaining against them because, they weren't making repairs. So that's one sort of gloss to that. So, but yeah, that was a good question.
Next question, I think this is more about harassment. So it's asking if the landlord tries to use a lawyer or maybe a private investigator to find out your social security number, your immigration status, so they can do more information on you. Is this harassment, and can you report this?
It depends. I think that the landlord gathering public information about you through a PI, I don't think would be like harassment per se. I think if the landlord's like demanding that information from you, and let's say their PI is like calling you up and demanding that information, that could rise to the level of harassment depending on the frequency of communication and what they do if you ask them to stop. When it comes to harassment, it's usually, a landlord investigating a tenant probably wouldn't rise to that level under most circumstances, but it would depend on the method, I would say, of investigation. And certainly, if the landlord is frequently contacting the tenant, this usually comes up in scenarios where the landlord's trying to buy the tenant out. So there's like this special harassment category of harassing buyouts where the landlord just like incessantly calls and says, hey, I'll give you $5,000 to leave tomorrow. I'll give you $5,000 to leave next week, and they're calling at all different hours. They're calling the family members of the tenants. They're trying, just like trying to throw money at the problem. That can rise to the level of harassment. And that's usually where we see the communication frequency of the landlord becoming a little more relevant.
This, I think, is a question about MFJ. Do you provide free legal services for tenants who had to pay for repairs out of pocket if the tenant would like to start a small claims case?
We don't, I'll take this. We don't really usually represent the tenants in small claims court. However, we do give legal advice. So if you call the intake line, a lawyer might be able to help you file that. And I actually have a form that you use to file a small claim. So I can send that to you, Kayla, and you can distribute that.
What can an undocumented tenant do in the event that they are facing an illegal lockout, or maybe even the threats of being illegally locked out?
That's a great question. So as Ezgi went over earlier in the presentation, there's no barriers to accessing housing court if you're illegally locked out based on your immigration status or your perceived status. So any tenant, in fact, any occupant of an apartment for more than 30 days in most cases does have a right to be brought to court before facing any sort of eviction. So if you've lived in an apartment even without a lease for for 30 consecutive days or more, you have a right to go to court before getting evicted. The landlord can't just like summarily change your locks. When it comes to threats of illegal lockout, your best vehicle in housing court would be to start an HP case for harassment. Documented threats of illegal lockout would constitute landlord harassment, and tenants who are facing that sort of situation can definitely reach out to us for, at the very least, we can give some general advice and counsel about documenting and dealing with landlords who are engaged in that sort of illegal activity.
Are there ways that tenants that are living in illegal basements and have no lease and they're paying in cash, are there ways that they can document that they are paying rent? Let's say in an event that a landlord is starting a non-payment case against them and they're like, well, I did pay you this rent, but they have no proof because the landlord demands cash.
By cash, is money orders included?
No, like actual physical dollars and stuff.
If they can get a receipt, I think that would help if they can get some sort of receipt that rent was paid.
And also the landlord is legally required to, if they're demanding cash payments, their agents or the landlord themselves are legally required to provide the tenant with a written receipt of those cash payments. That was one of the laws strengthened in the HSTPA last year.
So this again about the COVID financial burden, does this include medical bills or the increased price on goods like groceries and baby food?
It's a great question. So when it comes to the Tenant Safe Harbor Act defense that has to deal with financial hardship due to COVID, there are factors that are listed, and increased medical costs or the increased expenses are not one of the factors. It focuses more on loss of income itself. But, depending on the increase in burden, I could see there being an argument there that, that the increase in expenses in certain situations is so burdensome as to, constitute a loss of income. But it's an open question. I'll put it that way. It's the law leaves it to individual housing court judges to decide on this defense. So I don't think that you could, I think you could make that argument. I don't know how far it would go, and it would definitely depend on your documentation and the amount of the increase in financial burden. But I don't think that it's unavailable.
These next two questions I included just in case you might know the answers, but I think they're more something to ask for MFJ's immigration project. The first one is about the public charge rules. So I do recall that there was about a year ago, there was something being said that undocumented tenants are no longer at risk for the public charge rule regarding renters assistance, one-shot deals, food stamps, public assistance. But is this true, or was that just a rumor?
I won't venture to guess personally. I don't know, Ezgi, if you have any insight on that.
There is a risk. I don't know to which point it's being enforced, but I also, as Patrick said, I'm not that familiar with that part of the law.
And yeah, the next one, this is about tenants having issues with opening bank accounts for their escrow accounts and having the banks accept the EIN numbers. I will just say that certain banks just require other type of documentation to open account. I know several people that are undocumented and have bank accounts at TD Bank because they require less information. You can use a New York City ID for one, but they're asking what can be done, and maybe if there's a specific department in your organization that would be able to help in that regard.
Yeah, I don't, that's outside of my wheelhouse for sure. I think either our immigration or possibly our government benefits project might be able to help with that, but either way, they should reach. I think I would start with our immigration project, and you know what, I will. What could I, Kayla? Could I email you the information? Maybe you could post it.
Oh, absolutely. Yeah, we'll send it out to the registry.
Yeah, I just don't want to forget that part, so we can make sure people can access us.
And then the last question, very simply, I guess it's asking, but it's asking: are people that are renting out just bedrooms also protected under the tenant law? Like they are maybe a subtenant, they don't have a lease, they're just renting out a bedroom from someone who owns the apartment or has a lease themselves.
They are protected from what I know. And that would be more of a single room occupancy situation. And that's also included.
Yeah, what I would say is, so yeah, the short answer is that subtenants are protected from, from our interpretation of that law. I don't know how it's going to play out in court. There might be changes depending on individual judges' interpretation of the law, because again, the way it was constructed is judges are able to apply it, but the definition of who a tenant is pretty expansive under the Tenant Safe Harbor Act, and it seems pretty clear on the face of it that it doesn't just include people who have a written lease themselves. I mean, it could include subtenants, or even subtenants maybe without a written lease that just have an oral agreement with the what we call the prime tenant, the tenant who has the lease, to be protected in housing court.
Thank you. So I do see the chat box is going on talking about different things of like the FASTN funds and services for tenants experience need. But if you guys have any questions regarding rent arrears or public benefits questions, you can also call Housing Court Answers, and we'll have these individual conversations regarding specific needs. And yes, there's a question: send potential clients to their local home base. I do know that we have also referred people, regardless of their immigration status, to home base if they need assistance. But obviously you can always call our hotline, and you can also reach out to the Mobilization for Justice. I just wanted to share a story real quick. So I'm going to share my screen. All right, 1 second. Yes. I want to share my screen real quick. And this was a story from 2019. Really, it prompted me to want to also have this meeting. This isn't to say that this is going to happen for everybody. This is just an example, and I think of a really great success story of a Queens landlord who was fined $17,000 by the court for threatening to call ICE on a tenant who was behind on rent. She threatened to call immigration on the tenant, and this is in Jamaica, Queens. And unfortunately, I do see this as the Queensborough coordinator of Housing Court Answers, that Queens, which is the largest immigrant having borough, especially Jackson Heights, Jamaica, you guys know, and that there's also a lot of small landlords who don't have lawyers or don't really know the law and take things into their own hands without knowing what is legal, what isn't, and will do things like this and threaten to call immigration on their tenants or continuously harass their tenants. But I thought it was really interesting how this tenant was able to get their landlord fined for $17,000 for this situation. But unfortunately, this still happens to every day to undocumented or not even documented tenants, as the law says, even perceived documentation. Some people just think, well, you look foreign, so you must be. And it's unfortunate, but that's what we're here for. And so if you do have a tenant, a client, or you're a tenant yourself, and you have a neighbor, whatever have you, that has any questions, you can always call Housing Court Answers. Our staff is equipped to speak English, Spanish, and French. And we also have access to language line interpreters that, so if you speak any language, it could be Albanian, it could be Mandarin, we can get an interpreter on the phone with you just a matter of minutes so that we can still have this conversation. So, we're inclusive. Any language, come and speak to us. And yeah, if you guys have any other questions, this recording, I'm going to stop the recording now. But you can